Tiger Woods refused testing. Police said he looked impaired. So why didn't they even try to get blood? Court is in session. Tiger Woods crashed in Florida. Single vehicle rollover. The sheriff's office said he appeared lethargic, confused, and showed signs consistent with impairment after roadside tests. Tiger refused testing. And that's where this story really starts, because the sheriff's office later gave its reasoning for not going further. Basically, no obvious pill bottles, no obvious alcohol containers, not enough, in their view, to pursue blood. And that is the decision that puts this entire case on trial. Because once Tiger refused, the real question became, were they going to force the truth or not? And they did. If I'm the prosecutor and this file lands on my desk, my first question is immediate. Where's the blood? Because after a rollover with signs of impairment and a refusal, that is the case. That is the cleanest proof. That is the strongest proof. That is what turns suspicion into evidence. The specific substances and their blood levels. And in Florida, police did not need certainty. They just needed enough facts to go ask the judge. That's it. Not a guaranteed warrant, not a guaranteed conviction. Just enough to try. In my opinion, based on the evidence in charge, this case had more than enough to at least put the question in front of the judge. So if they really believe Tiger was impaired, why leave the cleanest escape hatch in the whole file? Now, to be fair to the defense, the sheriff's decision is simple. No pill bottles, no open alcohol, no clean chemical proof in the moment. And yes, legally, probable cause to arrest is not always automatically identical to a compelled blood draw. That is true. But here's the problem. That explains caution. It does not explain doing nothing. Now let's cross-examine the sheriff. This was a rollover crash, correct? Violent, sudden. People can be disoriented after a rollover. They can be in shock. They can even hit their head and not even be aware of it right away. You did not medically rule out a concussion or head trauma at the scene, correct? Now the field sobriety side. And this is Tiger Woods. Multiple surgeries, back issues, leg trauma. Those conditions can affect balance and coordination, right? Now alcohol. He blew triple zeros, correct? So alcohol is not your theory. This becomes a drug or medication case, right? So let's get specific. What exactly do you say impaired him? What drug? What medication? You didn't find any pill bottles in the vehicle, right? And you didn't find any medication on his person. Not even one pill. So as you sit here today, you cannot tell this jury exactly what substance, if any, impaired him. And you cannot tell them what level was in his system. Because a blood test wouldn't just show presence, it could show what it was and how much. And your office never got it. You never wrote a warrant. You never presented this to a judge, and you never even tried to obtain that evidence. However, at that very moment, you had the driving, you had the speeding, you had the crash, you had the rollover, you had your observations, you had your field sobriety tests, you had your interaction complete with Mr. Woods. You had everything you're telling this jury here today, and your office actually decided you did not have sufficient evidence, even for probable cause, to draft an affidavit and go to the judge to get a blood warrant. Yet now, you are aware that the state prosecutor sitting right here is asking this jury to believe that you have enough to prove this case beyond a reasonable doubt. Now, my ruling. So, was Tiger Woods protected in this case? Yes, I think so. Can I prove it in a courtroom? Probably not. But as a former criminal defense attorney, I can tell you this. The behavior of law enforcement in this case does not match the mission. And I know how much that matters. My first criminal trial was in 1996. A young man hit a marked police vehicle head on at night, totaled both vehicles. His blood came back at over 3 times the legal limit. And we still got him acquitted. So trust me when I tell you, DUI cases are already defensible, even with terrible facts and a blood draw, which is exactly why you do not hand the defense missing evidence. And here, when police say a driver looked impaired after a serious crash, and that driver refuses testing, the normal instinct is not hesitation. It is, go get the proof. And here, they left the strongest evidence untouched. And I do not think that happened by accident. Because if Tiger's blood had been drawn, the entire country might have learned exactly what was in his system and the concentration at the time of driving of any such substances. And I do not think the system wanted it badly enough to force it. But no, I'm not saying this proves corruption. But I am saying this. This looks less like the department trying to protect the public from Tiger and more like the department trying to protect Tiger from the public. That's my ruling. This is Crimes Digest, where we cross-examine crime news instead of reporting it. If you want more cases examined this way, subscribe, and I'll see you in the next episode.